I made the allegation, you can't fight me back or sue me back. I mean, it seems like that's what she's implying here.
Welcome to my channel. It was a week ago that Blake Lively and Justin Bond's lawyers were in the court arguing over the need of a protective order. And in my video that we talked about last week, my prediction was that the judge's decision would include a modified version of the one that Blake Lively proposed based on how the oral arguments went, and that he would designate certain portions of discovery as attorney's eyes only. I also stated that I believed they would not get the entirety of the protective order that they sought. I mentioned that the judge was particularly not impressed with some of the language that they were using. He described some portions of it as over Brad, and was specifically annoyed by language about high-profile people, and that he would not at all in any capacity close the court in any way, shape, or form, no matter what they said, or would he allow redacted things to be filed to the court without approval prior to filing, and that anything that comes into the court would become public. So, as I predicted, that's exactly what the order became. So you're going to see things on both sides today. You'll say Justin wins or Blake wins. I think this was expected probably on both sides. I think Justin's probably would have preferred to not have to do any of the attorney's eyes only. But the truth is that this protective order is actually not a bad idea because it protects both sides, and the judge saw it more than we're just going to protect. Blake was more like, we're going to protect both sides. Both sides have used this lawsuit to make publicity in the press. So the order was signed earlier this morning, and in a video yesterday, some of you had said, Tome Katie, I can read everything myself. I don't need you to read me the whole document. So I am going to spare you that. I read you the whole document. I'm just going to read you portions that I think you'll find particularly interesting. Here, the judge signed an order today, and he denied it in part, and he granted it in part. Like I was saying earlier, some parts of it he felt were over Brad. He also modified language in it, so it's not necessarily a full win. And I don't disagree with this order. I think it's good for both sides. One of the biggest issues for him was sort of navigating the right to privacy for non-parties of the suit that might be brought in unnecessarily, and whether or not the information they provide will be used against them by the other publicists that are involved in this case. And the issue for the judge specifically wasn't necessarily that Justin's going to use information or that Blake's going to use information, but rather the fact that there's publicists and managers and people on both sides that work specifically with having a relationship with the press, and knowing that they have such close access to the press, there was a need for a protective order for that reason. So this is sort of how he came to his decision. It says each of the Lively and Wayfair parties have filed claims against the other. Jones, the owner of a public relations company, has filed claims against her former employee. The parties have leveled accusations of theft of trade secrets and the disclosure of confidential sensitive information against one another. Discovery will inevitably involve some amount of sensitive business and personal information, that premature public disclosure of which could cause harm to the producing party or to a third party. So when I saw that, I was like, okay, so Blake has been in the court playing the victim, and obviously she's claiming to be a victim. But she was very dramatic in her arguments last week. The attorney was, that her safety was in peril, and that they're so dangerous and there's dead bodies, and a quote that she attributed to one of Baldoni's business partners, Steve Sarowitz. And here the judge is unmoved by that because he's saying that both sides have leveled accusations. So it's not just that Blake is a victim, but also Baldoni and Wayfair and the associated parties on that side are claiming to be victims. So you have two sides claiming to be victim, and it's right now only allegations in court. Nothing yet has been proven. So he's basically giving that an even playing field, and he's not taking any more weight into one or the other. And he's just saying that because both sides have made these accusations and both sides are engaging in it, this is going to be best for everyone, especially for non-affiliated or third parties that aren't actually being sued but could be brought into the situation.
There wasn't a dry eye in sight, and it was me who was sobbing, I will say.
So what he's going to do then is he's going to limit what will be actually AEO, and he referenced that the moving parties argue that an AEO provision is appropriate because of the risk that sensitive details revealed in discovery will become weaponized by the parties in the media, chilling third parties from producing discovery, and imposing an impermissible tax on the prosecution and defense of legal claims. The moving parties specifically note that potential harm to third parties who could have private and sensitive information spread through the press as a byproduct of this litigation. And then the Wafer responded that Lively has already disclosed sensitive personal information related to the alleged harassment. And they suggest that there's no need to presumptively designate material AEO at this time. And any need for material to be designated AEO could be determined as it rises. He says that the moving parties have shown good faith that this was a good reason, because it's critical, right? Now, so that the case can move forward, that they at least do this, because if they don't do this, it could unnecessarily slow things down, and it's more important to him that this goes quickly than it goes slowly, right? So he wants to make it so people won't be scared to give information and will participate in discovery. It's kind of like being the mediator here. So it says in particular, the disclosure to the parties of certain information that will invariably be exchanged during discovery, but which may not necessarily be to the prosecution. And defense of this case presents an incremental risk of annoyance, embarrassment, and oppression that cannot be effectively controlled by the court's model. And I think their biggest issue is that his current model has this provision where they have to sign a document that says they're not going to violate a court order, and then if they do, then they can go to contempt. But he doesn't know that that would actually work in this case, because if someone wanted to violate and leak it to the press, like one of the publicists, it would take so long for sanctions to actually be issued to that person, to that party. And by the time that came, the damage would already be done to the person or the third party that had that information disclosed. So another aspect of this AEO is that they're business competitors and both sides. So when they look at the model protective order, He believes it's not totally sufficient because both cases on each side have businesses that are competitors, and then there's actually allegations of sexual harassment. And because of that, there's a significant risk that disclosure of this information could be great. So, think of it as this: Stephanie Jones is a competing publicist to Melissa Nathan. Jen is a competitor to Leslie Sloan. So you have two publicists over on one side, you've got Melissa Nathan and Jen Abley on another side, and each of them have access to the press. And that's his biggest concern. It has nothing to do here that just is going to leak any of this information. It's not that it's dangerous for Justin to have this, but it's more like we need to keep this out of the hands of the publicists. So it says several individuals and corporations on each side of this are in the business of public relations or media and have access to the press. The details of this case have been closely followed in the media, and each side has accused the other of litigating the case in the media, and where confidential information is not disclosed to the media, it may spread by gossip and innuendo in those in the tight artistic community in a position to do harm to one or the other of the parties, but in a manner that might not be read or immediately detected. So what his concern is has nothing to do with Blake. It has nothing to do with Justin. It has to do with the PR people. And that not only could they go to the press, but they could also be in social situations. And they could start spreading gossip about Justin to competitive, or to studios, and equally on Justin's side, Jen and Melissa could do the same. I think I said a couple days ago that it almost feels like the public PR people are the whole reason they're in this mess to begin with. The PR people created a, quote, unstorm. So what he's going to do is he's going to limit the amount of what information can be designated as confidential, okay? And so when it comes to trade secret information.
And I think that, for the women I know who have seen this movie who have experienced any similar pain,
they're going to have to disclose all business and marketing plans for it. Ends with us to the other competitor, so both sides will be having to share. And there's no AEO for that period, but if has nothing to do with it, ends with us, that's what they can mark as AEO. So if Jen and Nate Melissa want to see what Leslie's PR strategy was for Blake before it ends, with us, they'll get it and they'll get to see it, but they don't get to see what Leslie's doing for someone else or foreign on for a project or for someone else. Okay, so he's not going to limit anything to do with the film. Medical records obviously will be marked AO, but that's going to be done for a different reason when it comes to medical information. He is saying that it will be marked AEO, but it may become necessary for information to become disclosed to a party at some stage, depending on what the contents are, and given the accusations the parties have made against one another. The challenges that the court would have enforcing a protective order against persons other than the lawyers. It's appropriate. So they'll initially designate medical information as AEO, but if it comes up later that it needs to become less confidential, or if it's going to become testimony, or if it's going to become part of the case, then it will no longer be AEO. They are not allowed to C, security party like security measures, so they don't get to see what the personal security detail is of Blake and Wayfair has already said. They don't care about that. And then highly personal and intimate information about third parties. So he says Lively has asserted claims for damages in the form of emotional distress. Some information of a personal nature regarding the parties will inevitably have to be shared with persons other than the attorneys the parties are making the accusations who are the subject of the accusations. And it says, and the parties who are making the accusations or who are the subject of the accusations have a right to participate. In the prosecution and defense of the claims, the attorneys have a need to consult with their clients. At the same time, it is in the nature of the discovery that the net will cast wide, and that each side will be forced to disclose to the other information of a sensitive and personal and intimate nature that is not necessary or even relevant to the prosecution or defense of the claims. The point is even more apparent with respect to non-parties. These persons have not signed up for this lawsuit, but by the virtue of Rule 45 subpoena, power, they will inevitably be brought into it. Their personal information, which may be contained in the documents to discover, may well be the least centrally relevant to the determination of the AIC action, blah, blah. Blah, blah, blah. So basically, they're going to give an AEO designation to non-parties, third parties. And then it says, before the parties make an AEO designation, the protective order places them the burden of determining that the information is not directly relevant to an allegation in the pleading. So if, say, they want Hugh Jackman's text messages or something, he would be able to, if he has texts that don't include stuff about it, ends with us, that's the kind of stuff that would be not relevant. But if it has anything to do with this case, that would not be considered attorney's eyes only. It's basically stuff that's going on in his life that has nothing to do with this situation. Same with Taylor Swift. So we're not going to say find out if Taylor and Travis's relationship is staged and fake. That's what I'm just saying. So he's going to be he changed. Some of the designations he said, some of it was just like way too broad language, like likely to cause competitive business, commercial, financial, or privacy injury is too broad for him. So he's going to say likely to cause comic, commercial, or privacy injury. They've narrowed it down to be stated that it may be marked only if it's highly likely to cause significant business, commercial, financial, or privacy injury. So it's not going to be as easy for them to get this. So at the end of the day, he's denied in part and he's approved in part. And then just to get the meat of it, there's what he will see. Here's the categories. He's trade secrets confidential. Business plans, marketing plans, strategies for clients, other than the parties in this litigation, confidential business projects or leads on projects for clients, other than the parties in this litigation, confidential creative projects or ideas, other than those involved in this litigation, security measures taken by parties or third parties, medical information of parties or third-part parties, and highly personal and intimate information about third parties and highly personal information about parties other than directly relevant to the truth or faulty of any allegations in this complaint, of the complaints in this case.
Watch the movie, I think, especially women, I think they're going to walk out of the theater feeling empowered and almost like, we all need a little bit of an Alyssa in our lives.
Oh, yeah.
So Blake and Ryan can only claim AEO for stuff that has nothing to do with the case. If they had conversations about Justin or the film that has to go forward, they only get AEO for stuff not directly, and the same thing goes for the third parties. So it's going to protect their personal secrets that are going on in their lives that have nothing to do with the film. So we're not going to get as much tea, I guess, as what, some people were hoping we were going to get all kinds of tea in here. And there's enough tea in the allegations in the case to begin with. There's a lot in here that really most of you won't even care about because some of this will never even see if it settles. We're not going to see any discovery anyway. And if it goes to trial, only going to see what's produced at trial, we're not going to see all the discovery anyway. That's what discovery is used. And if you've gone through a lawsuit, complaints can say a lot that may or may not be true. And I've been on the receiving end of really awful complaints that have made such vicious allegations against me that weren't true, and cases were dismissed. So I always have to remind myself when reading either party complaint that not all of this is actually going to be based in fact. And when things are done under information and belief, it truly means they don't necessarily have the evidence to prove what they believe this to be, and what discovery is going to allow them to do is get the evidence that they need to prove these claims a trial. Okay, so at the starting point, each one of them believes that they have grounds for these claims. All right, but at the end point, they have to prove it, and that's what discovery does. So that allows people to get interviewed for depositions. It allows documents to be reviewed, and it helps both sides build their cases, but also discovery can help disprove the allegations. So say they start going through the discovery, and they realize, well, Leslie Sloan wasn't as involved as we thought, or they realize Melissa, Nathan, and Jen Abel didn't do what we thought they did, or they start looking at the communications, and they realize that this all got blown up out of proportion on both sides, and that happens a lot. And that's why cases settle, because it comes to a point where it's like, this isn't benefiting me, this isn't benefiting you, and then you come to an agreement. And settlements do not have to include money, by the way. Now, Justin's lawyer states that they're not interested in settling. He's interested in proving his innocence. And so from my perspective, the only way he's going to win is if they go to trial and they're able to prove that this didn't happen, or if they can go through discovery, and through the discovery process, they can disprove literally all of her claims, which, think of it like this. There's a process called a summary judgment, and I just filed 1-in-1. In the case that I've been involved in for 3 years, it means you've gone through all parts of the discovery, and through the discovery process, you've determined that the other side doesn't have the evidence that they need to win, and that for that reason it should be discharged, and the summary judgment goes through C, like point by point on what is lacking in this person's discovery, and what you found, and why it won't be reasonable to go to trial. And then it can get discharged that way. Summary judgment is often used when a motion to dismiss fails, and it goes to that place after the exchange of discovery. I honestly wouldn't be surprised if either side were able to just get this out via summary judgment. And then if it goes to trial, it'll be up to a judge or a jury to deciding and how they do it. But when it comes to anything that is filed in the court, he was very specific about that. He says, all persons seeking to file redacted documents or documents under seal with the court have to follow a rule of practices in the civil cases. No person may file with the court redacted documents or documents under seal without first seeking leave to file such paper. All persons producing confidential discovery material are deemed to be on notice that the Second Circuit puts limitations on the documents or information that may be filed in a redacted form or under seal, and that the court retains discretion not to afford confidential treatment to any confidential discovery material submitted to the court or presented in connection with any motion, application, or proceeding that may result in order or decision by the court. So there is no presumption that confidential discovery material will be filed with the court under seal. They have to use their best effort to minimize sealing. So his thingies, like, okay, so when we get past discovery and you start filing motions, you can't just file stuff under seal. You have to do a leave to file request, and then you have to argue to me.
Be an actor. Like, I want to have.
So Blake and Ryan can only claim AEO for stuff that has nothing to do with the case. If they had conversations about Justin or the film that has to go forward, they only get AEO for stuff not directly, and the same thing goes for the third parties. So it's going to protect their personal secrets that are going on in their lives that have nothing to do with the film. So we're not going to get as much tea, I guess, as what, some people were hoping we were going to get. All kinds of tea in here. And there's enough tea in the allegations in the case to begin with. There's a lot in here that really most of you won't even care about, because some of this will never even see if it settles. We're not going to see any discovery anyway. And if it goes to trial, only going to see what's produced at trial. We're not going to see all the discovery anyway. That's what discovery is used. And if you've gone through a lawsuit, complaints can say a lot that may or may not be true. And I've been on the receiving end of really awful complaints that have made such vicious allegations against me that weren't true, and cases were dismissed. So I always have to remind myself when reading either party complaint that not all of this is actually going to be based in fact. And when things are done under information and belief, it truly means they don't necessarily have the evidence to prove what they believe this to be, and what discovery is going to allow them to do is get the evidence that they need to prove these claims a trial. Okay, so at the starting point, each one of them believes that they have grounds for these claims. All right, but at the end point, they have to prove it, and that's what discovery does. So that allows people to get interviewed for depositions. It allows documents to be reviewed, and it helps both sides build their cases, but also discovery can help disprove the allegations. So say they start going through the discovery, and they realize, well, Leslie Sloan wasn't as involved as we thought, or they realize Melissa, Nathan, and Jen Abel didn't do what we thought they did, or they start looking at the communications, And they realized that this all got blown up out of proportion on both sides. And that happens a lot. And that's why cases settle, because it comes to a point where it's like, this isn't benefiting me, this isn't benefiting you, and then you come to an agreement. And settlements do not have to include money, by the way. Now, Justin's lawyer states that they're not interested in settling. He's interested in proving his innocence. And so from my perspective,